Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to be discussing the P-2 visa. In other videos on this channel, I discuss things like the O visa for the United States, various other entertainer type category visa classifications, the P-1A, the P-3 visas. There are various visas which can be issued for those coming to the United States for various entertainment purposes, athletic purposes, essentially things that don't neatly fit into other various categories, that notwithstanding the fact that these are work authorized within these kind of categories if one is doing what's been specifically, what the visa has been specifically issued for. So I find it's often good to go directly to the horse's mouth, so to go to USCIS's site directly and just quote therefrom. The P-2 classification applies to you if you are coming temporarily to perform as an artist or entertainer, individually or as part of a group, who will perform under a reciprocal exchange program between an organization in the United States and an organization in another country. Eligibility criteria: you must be an artist entering the United States through a government-recognized reciprocal exchange program. In addition, you must possess skills comparable to those of the United States artists and entertainers taking part in the program outside the United States. Application process: in order to qualify for a P-2 visa, sponsoring labor organization in the United States or your U.S. employer must file Form I-129, petition for non-immigrant worker, pay the appropriate fees, etc. The thing to keep in mind with respect to this visa category is it's somewhat qualitatively different than the O visa category, which can be issued to entertainers coming to the United States, but does not have to be specifically associated with this sort of reciprocal exchange, cultural exchange type of entertainment. And I guess what I'm thinking of here is there's various sort of cultural entertainment type of events which can occur, which are specific to a given country. Like things like maybe an Oktoberfest festival in exchange with Germany comes to mind, various entertainers associated with that. Things like maybe a symphony orchestra from, or the Bolshoi Ballet, something on that level. Those type of entertainers, if it's in a context of like a reciprocal cultural exchange, this visa may apply. Again, it's somewhat different than those who are coming to the United States to work as, say, an actor, an actress, an entertainer, singer, something like this on, say, an O-type visa category, where it might not be so specific exactly what type of work or the exact specific thing that that individual will be doing at the time that they apply for the visa. And there's also not this governmental exchange component associated with the O that there is associated with this category. But that being said, for those who fit into sort of the circumstantial criteria of this category, this can be a rather useful and a rather straightforward way of getting in the United States with work authorization specifically associated with this type of activity.